And since our Prime Minister has proudly announced as the head of the G20 summit that one earth, one family, one future, I'd like to request our Honourable Union Minister through you, sir, that he has to consider our fishermen from Tamil Nadu also, because local issues are very, very important and it needs to be addressed. We are very happy. We welcome this bill, but still they have to take into account the plight of our fishermen. Hence, with all these suggestions and requests, I'd like to ask the Honourable Union Minister through you to take into consideration of the above points as well before passing the bill. Thank you very much.
Very good.
Sri Redappa. Sri Redappa.
Sir, I would like to thank the Honourable Chairperson for giving me the opportunity to speak on the Anti-Maritime Piracy Bill 2019. Sir, at the outset, I would like to bring out the importance of Indian Ocean. Sir, the sea lanes in the Indian Ocean are considered among the most strategically important in the world. More than 80% of the world's seamen trade is oil transit through the Indian Ocean choke points, with 40% passing over through the Strait Hormuz, 30% through the Strait Malacca, and 8% through the Bab el-Mandeb Strait. Further, roughly 55% of known oil reserves and 40% of gas reserves in the Indian Ocean region, sir. The increased significance of Indian Ocean region in the world geopolitics is one of the reasons behind the Pivot Asia policy, which former United States President Barack Obama had considered. The route between Asia and Europe and the east coast of Africa is used by 2,000 ships each month. The piracy in the Indian Ocean is not a recent phenomenon. According to the IBM Piracy Reporting Center, the total number of attacks in the Indian Ocean region that could be attributed in Somali pirates speaks in 2011, and when 237 incidents were incurred and soared 557 during the 5-year period between 2010 and 14. This number fell dramatically just 14 in the 6 years period between 2015 and 20, a drop that is widely regarded as a result of giant effort to reduce the crime at sea, sir. I would like to point out a few positives in the possible bill, sir. The applicability of this bill is exclusive economic zone. Sir, the Indian Penal Code is not valid for foreigners in international waters. Previously, pirates were prosecuted under the Indian Penal Code in 1860. However, Indian sovereignty is delimited by the outer boundary of its territorial waters, that is 12 nautical miles from the coast. Acts of piracy committed by a foreigner outside the Indian's territorial waters cannot be an offence under the IPC, and those accused piracy cases have been acquitted due to the lack of jurisdiction. However, the said legislation, if once implemented, will extend the scope of our jurisdiction to exclusive economic zone that is beyond 200 nautical miles from the Indian coastline, sir. The bill is necessary for economic development, sir. Sir, India's economic development is crucially dependent on the sea because of the critically the seaborne trade in the increasingly interlinked world, as well as because the potential of the vast economic resources of the ocean, sir. Indian maritime interests involved in safeguarding of our coastline and island territories, as also our interest in our EEZ, as well as in maintaining open, secure sea lanes in communication, sir. The third point is human risks, sir. The last year, 18 Indians abroad and crude oil carrier were kidnapped off the coast of Nigeria. Therefore, the risk attacked the lives of innocent Indians sailing in this region due to piracy incidents needs to be curbed at the earliest. Finally, Speaker, sir, India can become Vishwaguru with the implementation of this bill, sir. High seas are not under anyone's control. Most priorities that used to be captured till now used to be kept in a jail in Kenya administered by the United States. Thus, since right now no other country in the world has such laws in place, therefore implementation of such law will make India lead to the other nations in the collective fight against maritime piracy, sir. Hence, for all these reasons, I express our party's support for the bill. Thank you very much, sir.
Thank you. Vinayak Raut, Mr. Vinayak Raut.
धन्यवाद सभापति महोदय। एक समुद्री व्यापार और व्यवसाय के लिए एक बहुत बड़ी समस्या बनती थी समुद्री डकैती, उसके ऊपर सही इलाज निकालने के लिए और परमानेंट उसके ऊपर सॉल्यूशन निकालने के लिए इस बिल के माध्यम से एक सही कानून बनाने का प्रयास माननीय मंत्री महोदय ने किया, इसके लिए मैं उनको सबसे पहले धन्यवाद देता हूं। और सभापति महोदय, इस विषय के ऊपर बोलने के लिए मुझे अवसर दिया, इसके लिए आपको भी मैं धन्यवाद देता हूं। समुद्री डकैती उच्च समुद्रों पर व्यापार और वाणिज्य के लिए प्रमुख खतरों में से एक है। हिंद महासागर विश्व के तेल उत्पादन और वैश्विक समुद्री व्यापार में एक महत्वपूर्ण भूमिका निभाता है, लेकिन समुद्री लुटेरों, तस्करों और आतंकवादियों के कारण हिंद महासागर अत्यधिक असुरक्षित और अस्थिर है। यह पाया गया है कि समुद्री लुटेरों के हमले में दक्षिण पूर्व एशियाई देश सबसे अधिक प्रभावित बन चुके थे। यह अदन की खाड़ी में बढ़ी हुई नौसैनिक उपस्थिति के परिणाम स्वरूप है, जिसने समुद्री डकैती के संचालन को पूर्व और दक्षिण की ओर स्थानांतरित कर दिया और भारत के पश्चिम तट से उनकी निकटता बढ़ा दी है। खास करके सभापति महोदय, मैं बताना चाहता हूं कि 3 दिसंबर 2019 को एक कच्चे तेल वाहक पर सवार कई भारतीय, करीबन 18 भारतीयों को नाइजीरिया के तट से अगवा कर दिया और बातचीत के बाद कई दिनों के बाद उनको रिहा कर दिया। लेकिन नाइजीरिया के तट के पास समुद्री डकुओं के द्वारा अगवा करने की अन्य कई भी घटना इसके पहले भी हुई थी। 2020 में भी दशकों से भारत को समुद्री डकैती के अपराध से संबंधित किसी विशिष्ट कानून के अभाव में ऐसी कई घटनाओं को सामना करना पड़ रहा था और इसीलिए 1995 में यूनाइटेड नेशन कन्वेंशन ऑन द लॉ ऑफ द सी में एक महत्वपूर्ण संशोधन किया गया और यह बिल उसी प्रतिबद्धता का एक परिणाम है। एंटी मैरिटाइम पायरेसी बिल 2019 जो समुद्री डकैती से संबंधित अपराधियों के लिए व्यक्तियों के खिलाफ मुकदमा चलाने और हमारे जहाजों और चालक दल को सदस्य की सुरक्षा सहित भारत के समुद्री व्यापार को सुरक्षा को बढ़ावा देने के लिए एक अंतर्राज्यीय समुद्री डकैती विरोधी कानून बना रहे, ऐसा मैं खुद मानता हूं। पहले समुद्री लुटेरे पर भारतीय दंड संहिता यानी आईपीसी एक्ट के ऊपर 1860 के तहत सशस्त्र डकैती से निपटने के लिए प्रावधानों और विशिष्ट अदालतों के नौवहन अधिकार क्षेत्र के तहत मुकदमा चलाया जाता था। इसलिए भारत के जल क्षेत्र के बाहर किसी विदेशी द्वारा कई चोरी का कार्य आईपीसी के तहत अपराध नहीं माना जाता था सभापति महोदय, और इससे ऐसे अपराध निपटने के लिए यह बिल सही तरीके से एक महत्वपूर्ण बिल होगा और यह बिल सरकार को भारत के विशेष आर्थिक क्षेत्र के सीमा से सटे समुद्र के सभी हिस्सों के लिए एक प्रावधान करने का अधिकार इस बिल के माध्यम से मिल रहा है। सभापति महोदय, बिल केंद्र सरकार को संबंधित उच्च न्यायालय के मुख्य न्यायाधीश के परामर्श से प्रभावित कानून के तहत समुद्री डकैती के अपराधों के त्वरित परीक्षण के लिए कुछ अदालतों को नामित न्यायालयों के रूप में से निर्दिष्ट करने में सक्षम करेगा। लेकिन साथ साथ में मैं और एक भी विनंती करूंगा मंत्री महोदय से, जैसे कि पूर्व सांसद महोदय ने किया कि एक वेस्ट कोस्ट है, ईस्ट कोस्ट है, ऐसे क्षेत्र में भी न्यायालय का निर्माण होने की आवश्यकता है ताकि हमारे फिशरमैन को भी इस समुद्री डकैती जो है उससे कई समस्या को सामना करना पड़ता है। तो इस बिल में अधिकार क्षेत्र की सीमा, गिरफ्तारी और जब्ती, सजा और दंड मानवाधिकार पहलू के बारे में मुकदमे के लिए नामित अदालतों और प्रत्यर्पण के प्रावधान आदि के बारे में भी कई बातें स्पष्ट की है और उसमें वक्त में संशोधन करने की आवश्यकता भी रहेगी। मुझे पूरी उम्मीद है कि नया प्रस्तावित कानून निश्चित रूप से अधिकारियों को पकड़े गए समुद्री लुटेरों पर मुकदमा चलाने में सक्षम बनाएगा, चाहे उनकी राष्ट्रीयता कुछ भी हो, और यह सदन इसे अधिनियम बनाने में मदद करेगा। समुद्री डकैती पर समर्पित अंतर्राज्य कानून के कार्यान्वयन से भारतीय नौसेना या तटरक्षक को राष्ट्रीयता का परवाह के बिना पकड़े गए समुद्री लुटेरे पर मुकदमा चलाने में जरूर मदद मिलेगी और इससे भारत को समुद्री डकैती से निपटने के लिए अंतर्राष्ट्रीय प्रयास का हिस्सा बनाने में मदद होगी। साथ साथ में मंत्री महोदय से भी ये भी मैं एक विनंती करना चाहता हूं कि राज्य यानी अंतर्देशीय जो फिशरमैन है अपने अपने देश के अन्य राज्यों में, इसमें भी कई जगह पे समुद्रवार चलता है मंत्री महोदय जी। अभी जैसे कि साउथ के कई स्टेट के फिशरमैन महाराष्ट्र में आते हैं, गुजरात के महाराष्ट्र में आते हैं, महाराष्ट्र के अन्य कई जिले में जाते हैं, कई फिशिंग करते वक्त श्रीलंका में जाते हैं। तो ऐसे फिशरमैन को भी सही मदद करने के लिए या उनमें कुछ झगड़ा नहीं होने के लिए भी आप सही वक्त पे उसमें कानून बनाकर उनको भी मार्गदर्शन करेंगे, ऐसी मैं आशा व्यक्त करता हूं और सभापति महोदय इस बिल का मैं समर्थन करता हूं। धन्यवाद।
थैंक यू। श्री कल्याण बनर्जी।
Sir, I convey my thanks for giving me chance to speak on this bill. Sir, the Anti-Maritime Piracy Bill 2019 proposes Indian authorities to take action against piracy in the high seas. The bill brings into law the UN Convention on the Law of the Sea, while applies to the sea beyond the exclusive economic zone, that is beyond 200 nautical miles from India's coastline. India signed the United States Nations Convention on Law of the Sea on 10 December 1982 and ratified it on 29 June 1995. Piracy is an ancient phenomenon and its history dates to hundreds of years. It was only in the 20th century that the codification of piracy-related customary laws and practices began. Sir, the marine environment after the 1972 United Nations Stockholm Conference on the Human Environment and the conclusion of significant specific convention, the London Dumping Convention of 1972 and the MARPOL Convention of 1973 became broadly accepted objective. According to the 1982 United Nations Convention on the Law of the Sea, piracy is defined as an illegal act of violence or detention or any act of depredation committed for private ends by the crew or the passengers of a private ship. Sir, in accordance with the UN CLOS, the bill defines piracy as an illegal act of violence, detention or destruction committed against a ship, aircraft, person or property for private purposes by the crew or the passengers of private ship or aircraft. Sir, piracy there are different characteristics of piracies are there. I am not going there. Sir, I just come to very important part that apart from the International Maritime Organization as addressing maritime piracy for some time, sir, the Jeddah Amendment to the DGBT Code of Conduct 2017, DCOC, expand that so many activities are there in that. I am not going into details. During the period 2009 to 2019, over 500 Indians were captured by pirates around the world at various points of time. The United Nations Security Council, in a number of resolutions adopted since 2008, urged the UN member states to cooperate in investigation and prosecution of all persons responsible for acts of piracy, and further called upon states to criminalize piracy under their domestic law and to favorably consider the prosecution of suspected and imprisonment of convicted pirates. Now the question is that we can draw a line or can fence on a solid land, which is impossible to make a barrier or line on a liquid or on sea. Hence the system of state baseless is not applied by a state in such a manner as to cut off the territorial sea of another state from the high seas or an exclusive economic zone. Sir, I am giving one information, that's through my speech. The creeks along the coast in Gujarat and Sundarbans in West Bengal are the most preferred routes for smuggling and infiltrations. The security in EEZ is also very important, for which state police has no role to play. It is therefore important that imperative and corrective measures are implemented to address the inadequacies to realize the potential of maritime sector. ASG SCAG in its report has said that manpower shortage proved to be the major hindrance in functioning of marine police stations to vigilance of long coastline. The surveillance must be strengthened on international border, on high seas maritime border, and also special training to coastal police for posting in coastal police station. That's the problem is this training in the coastal police training, that's a very inadequate in our country, in every state where the sea coastal line is there. I will request the Honorable Minister to give stress on that, to see that these maritime police who are posted there, they should be well trained. Unless they are well trained, it cannot be detected, it cannot be captured. This is one of the arena which I have found, according to me, still we are weak in that. Now, sir, regarding punishment for piracy, the details procedure has been stated. I am not on that. I am on. See, the Supreme Court of India has also ruled that awarding a mandatory death penalty for an offence violates the Article 14 and 21 of the Indian Constitution. And hence it is arbitrary and unfair in nature. Even in Section 303 of the Indian Penal Code and Section 27, subsection 3 of the Arms Act 1959, which provided mandatory death penalty for offenders, has been struck down by the Supreme Court. Kindly take note of this and consider this part. Now, what I am suggesting, instead of death penalty, whether life for imprisonment. Imprisonment means here, you know, now the interpretation, there is a change by the Supreme Court. Till the death, life imprisonment, instead of mandatory imposition of the death penalty. Kindly consider that part. This is in England, The penalty for the offence of the piracy was a death penalty, but that has since been abolished. The penalty is now life imprisonment. That has been done. And India is also, our Supreme Court is also saying mandatory death penalty is a offending Article 14 and Article 21 of the Constitution. Mainly it is an offending Article 21 of the Constitution. Therefore, kindly just substitute these words with imprisonment for life if such person committing the act of piracy causes death or such endanger one's life on safety of a ship or an aircraft or any other means of public transport. Sir, so far my reading is concerned, so far I have made it, since I am a member of the Home Consultative Committee also, and occasions arose and where I got the scope to speak also. I will request 2-3 arenas that have to be given an emphasis, although we are supporting accepting that death penalty what I have stated, and this is all are because of the adaptations of the various conventions I have already said in my speech. Now the first is this, what I have observed that even the state, this coastal police, there are coastal police limited. There, in every state, the training is essentially required. Essentially required. Do not compare them with the just local police, other police. This has to be given an emphasis, and you introduce that centrally. That training has to be taken, how it has to be taken, etc. That has to be given. Secondly, in the border area, where the state arena is over 8, possibly 8 NM, after the 8 NM, immediately the national, in a national level, either your border security or whatever it may be, that you have to take care about that, because immediately after 8, the national level police, whoever is in charge, they have to take the responsibility of that. This is the arena. Arena is really remain no one's arena, and all that smugglers and all that things are being done in that arena. Kindly take care about this, and I have already said about the death penalty. With this, sir, of course, this bill was more earlier it was required. We are doing it. Support.
Thank you. Sri Alok Kumar Suman.
धन्यवाद सभापति महोदय, आपका मैं आभार व्यक्त करता हूं कि आपने द एंटी मैरीटाइम पायरेसी बिल 2019 पर बोलने का मौका दिया। महोदय, जैसा कि हम सब जानते हैं कि भारत के पास समुद्री डाकुओं की पायरेसी के लिए कोई कानून नहीं है। उसको इंडियन पेनल कोड 1860 के तहत संप्रभु भारत के क्षेत्रीय जल यानी समुद्री तट से 12 नॉटिकल मील तक ही जो समुद्री डाकू या कोस्ट गार्ड के द्वारा पकड़े जाते हैं उनको प्रोसिक्यूट किया जाता है। यह विधेयक लाया गया है कि इंडियाज एक्सक्लूसिव इकोनॉमिक जोन की सीमाओं से सटे या उसके परे सभी हिस्सों यानी हाई सी पर समुद्री डाकुओं द्वारा जो घटना हो, जो पकड़े जाएं, उसको दंडित किया जा सके। महोदय, दिस लेजिस्लेशन is an outcome to the commitment made by the India by signing the United Nations Convention on the Law of the Sea in the year 1982. भारत ने इस कन्वेंशन को 1995 में रेक्टिफाई किया। इस विधेयक के पास होने से भारत के समुद्री व्यापार से जुड़े सभी सेफ्टी एंड सिक्योरिटी की जो बात कही गई है, इसे पूरा करना आसान नहीं दिखता। वर्ष 2009 से 2014 तक की आईएमओ की रिपोर्ट के आधार पर 1173 पायरेसी और आर्म रॉबरी वेस्ट अफ्रीका और अपने तटवर्ती क्षेत्रों से रिपोर्ट किया गया है। इस अवधि में 500 भारतीयों को समुद्री डाकुओं द्वारा पकड़ा गया, जिसका अभी तक कुछ पता नहीं है। महोदय, अगर हम विश्व स्तर पर बात करें तो 2010 से 2021 का आंकड़ा देखें तो वर्ष 2010 में 4 से 45 जहाज़ों पर समुद्री डाकुओं द्वारा अटैक हुआ। वहीं 2020 में 195 और 2021 में 132 समुद्री जहाज़ों पर हमला हुआ। महोदय, यूनाइटेड नेशन ऑफिस ऑन ड्रग एंड क्राइम 2018 के रिपोर्ट के अनुसार 6 व्यापारिक समुद्री जहाज का हाईजैकिंग विश्व स्तर पर हुआ। 13 जहाज़ों पर अटैक के कारण आग लगी, 130 लोगों को बंदी बनाया गया और 78 अधिकारियों को जो जहाज़ों पर नौकरी करते थे उन्हें अगवा किया गया। इन समस्याओं को देखते हुए इस विधेयक में जो प्रावधान किए गए वह निश्चित ही समुद्री रास्ते से होने वाले व्यापार को सुरक्षा मिलेगी, लेकिन यह संदेह है कि यह बिल जान माल और इकोनॉमिक नुकसान को बचा सकेगी, क्योंकि इसका फाइनल करने के लिए केवल कुछ ही देशों यानी कि 4 ही देशों के लेजिस्लेशन को कंसल्ट किया गया है, जबकि समुद्र से सटे देशों से अधिक कंसल्टेशन होना चाहिए था। महोदय, पायरेसी का जो विषय है उसमें मंत्रालय का इन्वॉल्वमेंट, कई मंत्रालय का इन्वॉल्वमेंट है, जैसा कि मिनिस्ट्री ऑफ एक्सटर्नल अफेयर्स, मिनिस्ट्री ऑफ होम अफेयर्स, डिफेंस, शिपिंग, लॉ एंड जस्टिस। इसलिए इस विषय में आवश्यक है कि सभी मंत्रालय या एजेंसी या डिपार्टमेंट्स का रोल क्लियर डिफाइन होना चाहिए, जो कि इस बिल में नहीं दिखता है, जो कि इफेक्टिव कोऑर्डिनेशन के लिए आवश्यक है। महोदय, मेरा इस बिल में यह सुझाव है कि कोलैबोरेटिव इंटरनेशनल काउंटर पायरेसी उपाय यूनाइटेड नेशन सिक्योरिटी काउंसिल, इंटरनेशनल मैरीटाइम ऑर्गेनाइजेशन एंड कॉन्टैक्ट ग्रुप ऑफ द कोस्ट एंड सोमालिया के साथ हो तथा इसका प्रावधान भी इस बिल में शामिल किया जाए। साथ साथ ये भी मेरा कहना है कि नेशनल कमांड कंट्रोल कम्युनिकेशन इंटेलिजेंस नेटवर्क, इंटरलिंकिंग 51 IN एंड ICG स्टेशन, जॉइंट ऑपरेशन सेंटर्स, नेशनल AIS चेन और कोस्टल रडार को इस बिल के माध्यम से मजबूत किया जाए ताकि समुद्री व्यापार रास्ते को सेफ्टी और सिक्योरिटी मिले। महोदय, इस बिल के अध्ययन से यह भी महसूस हो रहा है कि इंडियन ओरिजिन के जो सस्पेक्टेड और हाई सी में एक्ट ऑफ पायरेसी में इन्वॉल्व हैं उनका एक्स्ट्राडिशन के लिए इंटरनेशनल कोऑपरेशन के प्रावधान में सुधार की आवश्यकता है। महोदय, ऐसा पाया गया है कि जो एक्यूज डेथ पेनाल्टी के लिए हैं उसको एक्स्ट्राडिशन करने में काफ़ी परेशानी होती है एवं शर्त के साथ एक्स्ट्राडिशन होता है कि डेथ पेनाल्टी नहीं दिया जाएगा। ऐसा कमिटमेंट सरकार के द्वारा किया जाता है। अतः मेरा इस बिल में ये कहना है और ये सुझाव है कि डेथ पेनाल्टी की जगह उम्र कैद या 12 साल या 16 साल की सजा हो और इस सब सुधार करते हुए इस बिल को पारित किया जाए। धन्यवाद सभापति महोदय।
Thank you. श्री दैनिश लली।
धन्यवाद सभापति महोदय कि आपने मुझे एंटी मैरीटाइम पायरेसी बिल 2019 पर बोलने का मौका दिया। सर, बहुत ही इंपॉर्टेंट बिल है। 2012 में ये बिल, सर डिपार्टमेंट का कोई मिनिस्टर नहीं है यहाँ पर मौजूद। सर नहीं सारे सब नहीं, हु इज टेकिंग द नोट? All ministers were talking to each other, to their colleagues.
No, he should speak and will come. Please.
चलिए खैर, यही सीरियसनेस है सरकार की। सभापति महोदय,
Yes, I know.
ओके, चलिए, ठीक है। यही सीरियसनेस है सरकार की। बहरहाल देर आए दुरुस्त आए। 2012 में इस बिल को इंट्रोड्यूस हुआ था, 14 से 19 का टाइम निकल गया। अब ये बहुत ही इंपॉर्टेंट बिल है, इसकी सीरियसनेस को इस तरीके से खत्म ना किया जाए। मैं सभापति महोदय, मैं आपके माध्यम से सिर्फ इतना ही कहना चाहता हूं। सभापति महोदय, मतलब ट्रेजरी बेंचेस का ये हाल है, अपनी गलती मानने को तैयार नहीं है और जो है शोर मचा रहे हैं। मुझे तो अपनी बात करने दीजिए, मुझे तो अपनी बात करने दीजिए। आई हैव ऑलरेडी एग्रीड।
प्लीज एड्रेस द चेयर, प्लीज।
सभापति महोदय, मैं तो आप ही को एड्रेस कर रहा हूँ प्लीज। अब ये जो है बार बार डिस्टर्ब करें, मैं तो ये कह रहा हूँ ये इतना अच्छा लेजिस्लेशन है, बहुत जरूरी लेजिस्लेशन है। मैं सरकार को कॉम्प्लीमेंट कर रहा हूं कि देर आए दुरुस्त आए, ये बहुत जरूरी है, बहुत जरूरी था। और मैं इस बात को मानता हूं कि पहले जमाने में धरती पर जंग हुआ करती थी, फिर हवा से हुई। अब असली खतरा पानी के अंदर है, और पानी के अंदर जो है आने वाला वक्त अगर कोई युद्ध होगा तो वो पानी पे ही होगा। और पानी के अंदर अगर सिक्योरिटी के लिए हमारी सरकार जो है सीरियस नहीं होगी तो ये बहुत उसकी बात है। इसलिए मैं तो कॉम्प्लीमेंट कर रहा हूं कि सरकार इस बिल को लाई है, अच्छा बिल है। मैं सभापति महोदय, मैं सिर्फ इतना ही कहना चाहूंगा कि देखिए ये 1982 में यूएन में ये हमारा जो कमिटमेंट था और फिर रेटिफाई किया 1995 में, उसके तहत ये बिल लाया गया। यूनाइटेड नेशन कन्वेंशन ऑन लॉ ऑफ सी अडॉप्टेड बाय इंडिया इन 1982 एंड रेटिफाइड इन 1995। लेकिन जो मेरे से पहले सभापति महोदय कुछ कुलीग्स ने यहां प्रश्न उठाए हैं, मैं उन पर भी आना चाहूंगा कि ये अभी तक जो हमारा सी के अंदर, समुद्र के अंदर इकोनॉमिक जोन होता था, उस पर हमारा अख्तियार था। लेकिन समुद्री डकैत जो होते हैं, जिनको हम पायरेट्स कहते हैं, ये किसी से छुपा नहीं है कि सैकड़ों बेगुनाहों को, भारतीय बेगुनाहों को उन्होंने किडनैप किया, कई की हत्याएं भी हुई। लेकिन क्योंकि कानून ना होने की वजह से वो सब, उन पर कोई बड़ी कार्रवाई नहीं हो सकी। कानून लाया जा रहा है, अच्छी बात है, लेकिन कानून बिल जो है वो ऐसा होना चाहिए, कानून ऐसा लाया जाना चाहिए क्योंकि इसके इंटरनेशनल रिपरकशंस भी होंगे। मैं व्यक्तिगत रूप से और इस सदन में कई सांसद जो हैं ने ये बात रखी कि डेथ पेनल्टी जो है वो बहुत, ऑनरेबल सुप्रीम कोर्ट ने भी कहा डेथ पेनल्टी शुड बी गिवन इन द रेयरेस्ट ऑफ द रेयर केसेस। लेकिन यहां हम अगर अटेम्प्ट टू मर्डर अटेम्प्ट को भी डेथ पेनल्टी उसका जो है क्राइम तय कर रहे हैं तो वो वाकई चिंतनीय है। मैं ये चाहूंगा क्योंकि जो लॉ बने उसको, क्योंकि इसका इंटरनेशनल लेवल पर भी इसकी स्क्रूटनी होगी, तो हम ये चाहेंगे कि डेथ पेनल्टी ना रह करके जो लाइफ इंप्रिजनमेंट है, लाइफ इंप्रिजनमेंट मीन लाइफ इंप्रिजनमेंट होना चाहिए पूरी लाइफ के लिए। और इसमें ये क्लॉज भी हो जाए कि सरकार को कोई रिमिशन देने का अख्तियारात ना रहे। जैसे इटली के 2 नागरिकों को जो पकड़े गए फिशरमैन्स की डेथ में, उनको छोड़ दिया गया, और यह जैसे गुजरात के अंदर अभी बिल्किस बानो के केस में सरकार ने लाइफ इंप्रिजनमेंट को 14 साल की सजा को रिमिशन किया। इस बिल के अंदर ऐसा क्लॉज डाला जाए कि जिनको गुनाह सजा दी जाए वो लाइफ इंप्रिजनमेंट किया जाए, डेथ पेनल्टी ना हो, लेकिन सरकार के पास रिमिशन का कोई अख्तियारात नहीं रहना चाहिए। इन्हीं शब्दों के साथ मैं अपनी बात खत्म करता हूं। बहुत बहुत शुक्रिया।
श्रीमती सुप्रिया सुले, व्हाट इज इट?
किस बानों का मामला है सर, वो सब जुडिस है। जो इन्होंने बात किया उसको एक्सपंज कर दीजिए सर, आपसे ये रिक्वेस्ट है।
आई विल लुक इनटू, चेयर विल लुक इनटू। सुप्रिया सुले, you made your submission, chair will look into, don't worry. Supriya Sule, nothing will go on record except Supriya Sule, please.
What's wrong with it?
Sir, thank you very much. I stand here in support of this very important bill that we are all discussing today. I appreciate all the points and the clarifications the Honourable Minister has given. So there's really very little left in the scope of the bill. I would, on the outset, like to thank the External Affairs Ministry, which is always very indulgent. Every time there is a crisis of anybody, either from my state or my constituency, every time I've reached out to them via a tweet, they've been most helpful. So I would like to put it on record and thank the Minister and the entire External Affairs Mantralaya for all the good work that they do. But there are a few suggestions. देखो अच्छे को अच्छा बोल रहे हैं. There are just few suggestions and clarifications I would like to ask the Honourable Minister. Most points are already covered, so I won't repeat them. But look at the Russia and the Ukraine war. During this war, there has been an incident where there is a boat which was full of food, which was attacked. Now, how do we deal? We all know, and many people before me have talked about it. Now, the next wars are not going to be physically attacking each other. These are going to be cyber attacks. So in this bill, there is nothing that has really come clearly about cyber attacks or how you're going to address cyber attacks in the future, because this bill is not only about today or yesterday, it's about something we want. Legislation also has to be very futuristic for 25 years, 30 years. Of course, we can change it and we evolve while the journey goes on. But in today's day and age, the only disappointment for me is there's no mention of any cyber attacks or how are we going to handle a situation like that. Because still that boat with food was attacked and nobody still knows who's taken it, how it's gone, where is it gone, and millions of people are hungry because of this gap or disruption that has come. The other point is talking about extraditions. Also, a lot of people did talk about extradition. Sir, extradition treaties are something, because if we arrest somebody or we want to arrest somebody and the person leaves the country, how are we going to bring them back in a time-bound manner? Because otherwise they'll be going. And I didn't want to make it political, but I would just like to give a small example. And please, I'd like to put it on record. I'm just drawing parallels for laws that we have made. And I'd like to give two examples. It's like the Nirav Modi case. Have we been able to extradite him and bring him back? The answer is not yet. So this is not a political point, but if we not been able to bring somebody back who has created such a big fraud, is what we hear from the government for so many years, how are you going to implement this law is my first question. That's the parallel I'm drawing. So, and the second parallel I'd like to draw, because my colleague and friend P.P. Chaudhary as well as Manish Tiwari both talked about it, you are drawing a parallel of this law when you talked about clause 11 where you talked about presumption, and you both took the example of PMLA. Now, I'm just broadening the scope. Again, this is not a political point. Again, I reiterate, I'm drawing a parallel. I'm not making an allegation. But in PMLA, again, it goes the same way is what I understand from what P.P. Chaudhary, and these are all lawyers. I'm not a lawyer, so I don't understand law as well as these two lawyers understand it or interpret it. I am just a novice at all this. So my question to the Honorable Minister is that if PMLA, like you rightly, both of you drew parity in it, that the whole, you have to prove that you're innocent. Now, I'll give you a small example of Sanjay Raut, who happens to be a part of this thing. He was arrested. He was left after 103 days. And the order which came out said that, I'm just using it as a parallel. I'm not making an allegation. So all that he said was, the order says, I'm not saying, this is what the judge and the court says, that there was no case against him and how was he arrested. So my limited question to you is that you yourself, I mean people from the Treasury as well as the opposition, has drawn the same parity that PMLA has ambiguity and it has presumption. So I think we should be careful while making laws, and I clearly remember, I'm so glad Mr. Dubey is in the House right now, because he talked about this ambiguity when this bill of PMLA was discussed. And I still remember, and he said it can. Now I'm not getting into the merits whether this government is using it on the opposition or not. That's not what I'm here for. That's not what I want to debate here or discuss here. My limited point is that when we make laws which are so important, and if we feel, and like a consensus of the House, that everybody's supporting this law, but if there is ambiguity and there is presumption, then should we make, I may be mistake, maybe a wrong word, but should we follow, if we have doubts about what we did in PMLA, should we repeat those ambiguities and presumptions so that no law should get misused? That's my limited point. So I just want this clarification about the death penalty. Plenty has said about clause 3, the Chinese naval presence, but I know these are very sensitive issues, and I do respect that the Honorable External Minister may not be able to speak freely about these relationships. This is not also the agenda for it or the place for it, but I would like to request him on this occasion that there is always in society and in newspapers, if you read, there is always this sort of, the pot is boiling somewhere. So if the External Affairs Ministry would have a broader discussion on our relationships, because Meenakshi Lekhi ji was very kind enough by reading out all the accolades of this government and so many wonderful things that they have done and hosted so many people and been hosted by so many people. We're all very proud of it as Indians. But we would like to know, And why not have a broader discussion on China-India relationship? I think this bill is welcome, but we can't leave China and our relationship with all our neighbors when we discuss these kind of bills. So my only request to you is, while I draw these two parallels, one, you missed my one point, so I'll just repeat it quickly, is about cyber attacks. Because in Russia and Ukraine, in that entire fight, there were food ships which were taken. Now, how do you bring accountability, or who do you really punish in such a situation, which is not covered here? So just two short points, either cyber attack clarification, and Mr. Chaudhary and Manish Tiwari drew the parallel of PMLA. So if you could kindly clarify. And I support this bill. Thank you very much.
Sri Mohammed Bashir.
Sir, I support this bill. I feel that this is in the best interest of the nation. With coming to the bill, sir, with regard to definitions, there are clarity in this. There is no ambiguity in this. And in that way also, it is drafted nicely. Sir, the Committee on External Affairs, which scrutinized this bill, has said, I quote, committee therefore desired to cover all means of transport on water and sea. The word vessel should be added along with the ship and aircraft. Moreover, along with the crew, the passengers and the presence of any other person on ship, bar aircraft, and private ship is also possible. The committee, therefore, would like that the word any person should also be incorporated suitably, and the ship and the aircraft should also be defined in two separate subclauses in the light of definition of the object and the relevant act to cover all kinds of possibilities. I hope that government will seriously consider this observation of the Committee on External Affairs. Sir, this Act stipulates volume of punishment, and India's need to have a separate legislation on this, and necessity of establishing the designated courts to address this issue. All these kind of things are most welcome. Sir, this widen the scope of lawmaking. The bill has been drafted in accordance with the United Nations Convention of Law and Sea adopted by India in 1982 and ratified in 1995. The committee now hope that the new proposed legislation will definitely enable the authorities to prosecute the apprehended pirates, irrespective of the nation. The number of UN resolutions have been passed to facilitate the nation to enact legislation of the piracy by adopting definitions suggested. So that also may kindly be taken into consideration. Sir, the need of legislation, I need not say much about that. That is very, very vital because, sir, this kind of crimes in this sea are increasing day by day, whether it is in the way of robbery or any kind of ill motive, this kind of things are increasing. A dangerous situation has arisen in the country, not only in India, other countries also, sir. Our committee has suggested after 2008, the major part in piracy attack was witnessed in the Gulf of Aden by pirates of Somalia. Committee also observed that the threat of piracy has mushroomed in enormously. That also is a very important thing to be noted, sir. Sir, and I would like to make 2-3 suggestions, sir. Further probe should be done in order to make the things in a proper way. What are the costs of piracy and how to do this compare to the expenses required for mitigation? 2, sir, what is the best way of countering armed maritime violence in region chronic lawlessness and anarchy? 3, sir, is a current international legal framework for countering piracy is sufficient or not? If not, what the government is going to do in that? What is the extent of government responsibility for countering piracy and what role should be a private sector can do in this? These are all certain things which I would like to say, sir. Anyhow, sir, it's a very good legislation and it is a very good intention. I support this wholeheartedly. Thank you very much, sir.
के सुरेश जी 5 मिनट एन के प्रेमचंद जी 6 बजे
प्रेमचंद्र
करेंगे 6 बजे.
थैंक यू Thank you, Mr. Speaker, sir, for affording me this opportunity to speak on this anti-maritime piracy bill 2022. Sir, I fully support the bill. Honorable Minister, please. So, first of all, I would like to congratulate the Honorable Minister in comprehensively piloting the bill in a very structured and diplomatic manner, for which I would like to place it on record our appreciation. It's really a model to all other ministers also, the way in which it was presented. And also I would like to take this opportunity to thank to the Honorable External Affairs Minister for accepting my amendment. My amendment number 6 is accepted in your official amendment, for which also I am thankful to the Honorable Minister for accepting my amendment and moving it as an official amendment. Pardon? Yeah, other 5 amendments I will be moving, it will be accepted in future. Sir, it is quite unfortunate to note that India, as such a larger country, is having no separate, distinct domestic legislation in dealing with the piracy issues. The menace of piracy is increasing like anything, and we are adversely being affected because of the reason by which we are not having a domestic legislation so as to combat the piracy in the seas. Sir, our country, especially the Indian Navy and the Coastal Guard, is facing big difficulties in combating the maritime piracy only because of the reason by which we do not have a comprehensive legislation to combat this piracy in the maritime piracy. So my first suggestion is, sir, I would like to draw the attention of the Honorable Minister regarding the Italian Marines case, that is Enrich Lexica case, which was well agitated in the international courts of justice, and even the Supreme Court has also dealt in detail. I would like to draw the attention of the Honorable Minister, in which also still the judicial proceedings are going on. When 2 fishermen belonging to my constituency in Kollam, Nindagara, was brutally killed by the Italian Marines, big controversy has come regarding the jurisdiction where the case has to be agitated or the case has to be instituted. Such a big problem was there, big controversy was there, unfortunately, and the justice was given to the victims or the relative successors of the victims after a long time. So my suggestion to the Honorable Minister and the government is, we should have a comprehensive legislation so as to determine the jurisdiction in the case of this international waters or waters according to the norms and guidelines of the International Convention. Because United Nations Convention on Laws on the Seas and clause is specific. So if the country, the domestic countries or the signatory countries or the signatory states are having ample freedom to have legislation of their own, but it should be within the stipulated norms of the convention, rules and regulations. If that be the case, my first suggestion is the government of India should have a comprehensive legislation in respect of the crimes in the seas. Sir, coming to the bill, I fully endorse the views, and it is a scrupulous scrutiny of the provisions of this bill by Manish Tiwari ji regarding clause 3, clause 4, clause 6 and other provisions of the bill. So regarding the clause 3, it is absolutely a correct fact, because the death penalty, it is being disapproved by the Honorable Supreme Court. It is in the rarest of the rare cases it is being given. Now, by way of the official amendment, you are providing a discretionary right to the Supreme Court or to the concerned court. Yes, it is absolutely okay, and we fully welcome the official amendments. But at the same time, we have to be more clear regarding the jurisdiction of the cases and the way by which the case is to be investigated. So regarding, clause 6, you are defining a police officer. That is, notwithstanding anything contained in the code, the central government, for the purpose of this act by notification, confer the powers of arrest, investigation and prosecution of any person exercisable by a police officer under the code. So I would like to move an amendment. The police officer means the police officer has to be designated. What is the rank of the police officer? That has to be designated in specific. Otherwise, it will also be creating problem in the future because it will be agitated in the courts of law. And also regarding so clause 8, for the purpose of providing speedy trial of offences under this act, the central government has, after consulting the Chief Justice of the concerned High Court, my suggestion is after getting concurrence from the Supreme Court, so concerned Chief Justice of the concerned High Court, that has to be made. That is an amendment which I have already given notice of an amendment. And it is a welcoming step on the part, because I am also part and parcel of the Standing Committee on External Affairs. We had threadbare discussion of this bill, and we had a very scrupulous scrutiny of the bill, and most of the suggestions of the Standing Committee has been accepted by the government, for which also we are thankful to the government. And this proclaimed offender in absentia, that has been removed. And also we have to be very careful about clause 11 of the bill. That is sir, burden of proof. It is a well accepted jurisprudence principles of Indian jurisprudence principle that you are, unless and until you are convicted, the presumption of law is an innocent. The burden of proof is on the convict. I don't know the legality of this clause in the courts. When this will be agitated in the courts of law, it will be a clear case of confusion, though that has to be clarified by the Honorable Minister. These are the provisions by which I would like to seek clarification on these issues. And another issue which I would like to highlight or draw the attention of the Honorable Minister regarding one of the major issues. Recently it has occurred. Now 30 Indians. I would like to draw the attention of the Honorable. This is also in the name of piracy. 30 Indian citizens have been arrested and they have been captured by the request of the country, the Nigeria. They have requested for arresting 30 Indians who were in a vessel, out of which one third officer who belongs to my constituency, one Vikraman Nair. He is the third officer. He is also now in facing trial in Nigerian courts. I would like to urge upon the government and the minister, please look into the matter, and probable and maximum diplomatic assistance has to be provided them. And nowadays we are getting series of complaints from them. So, yes, sir. They are not even allowed. They are not even allowed to have the mobile phone to their relatives in the country. So kindly have a diplomatic intervention in this matter so as to rescue all these Indian prisoners or all these persons who are facing trial in Nigeria. With these words, once again I support this bill. Thank you very much, sir.
K. Sureshji.
Thank you, Speaker, sir. Give me opportunity to participate in the discussion of this important bill, the Anti-Maritime Piracy Bill 2019. So the bill brings the UN Convention on the Law of the Sea into domestic law and enable Indian authorities to take action against piracy on the high sea areas. What essentially one gets to understand is that through the bill, the government of India becomes a party of the UN-led International Convention on the Law of Sea and get more to our difference of piracy. Our deterrency on the piracy. However, there are certain areas of concern regarding the ambiguity present in the bill. Before moving to those issues, let me remind you to current incident wherein 16 Indian seafarers of merchant vessels named Heroic Idun, who are now under the custody of Nigerian Navy and are taken to the land of interrogation, which is far from any judicial dignity. Just now, Honorable Member Sri N.K. Pravindran also mentioned one Vijit Vikraman case. So this is very much embarrassment of their family as well as the members of Parliament in Kerala. The parents of this Vijit Vikraman and others contacted us. We also contacted to External Affairs Ministry as well as our Embassy of Nigeria. But we couldn't get a proper reply from the External Affairs Ministry and also our embassy. They are not giving proper reply or not given any intervention of the results. So I would like to again bring your attention, sir. Still this problem is not solved. Their family members are very much shocked, and I would like to request to sort out this problem at the earliest. Sir, and also, sir, many of the vessels, the poor vessel workers, those who are working in the maritimes, they are unnecessarily arrested by the Nigeria, African, especially the Ghana, Nigeria, so many countries. So without any reason, they are deliberately arresting the vessels and taking to custody. This is the situation time to time in our Indian workers, those who are working the various vessels. So I would request the government to initiate further discussion to secure the release and help them reach safely India fast possible. And any discussion on maritime piracy, where India is a party to, must consider the pain and desolation of illegal detaining of Indian seafarers or the other nations, and securing them must be policy priorities. So, Speaker, sir, let me come to the other issues pertaining to the bill. Jurisdiction issue. The bill will be applied to the sea beyond exclusive economic zone, EEZ, that is beyond 200 nautical miles from India's coastline. However, it is unclear if it will apply to EEZ that extend between 12 and 200 nautical miles from the coast of India, which means that area of jurisdiction being unclear will result in loopholes for pirates and other criminals. The government must take it up the provide clarification, sir. The bill states that for the committing acts of piracy, the convict shall be punished with imprisonment for the life of death. It is unclear in the bill that how the overlap of the 14 years term and the life term will be determined, since committing an act of piracy will necessarily include participation as well. Sir, I'm
के सुरेश जी तक बोलने तक बढ़ाई जाती है, पर 2 मिनट में खत्म होगा.
Yes, sir. I'm concluding, sir. Sir, issue with the death penalty, Supreme Court of India has advocated for the use of extreme punishment in the rarest of rare according to the top court. The death penalty violates Article 14 and 21 of the Constitution, frame the piracy in the ambit of domestic jurisdiction, and how to address the areas of overlap from the what makes rare case, and how the brutality piracy is defined needs clarity. This bill further states that the designated court will not be jurisdiction over offence committed on the foreign ship unless intervention is requested to the country of origin of the ship owner or any other person on the ship. But the question remains as what the crime committed to a foreign ship is intended to harm India's interest. Sir, finally, these questions need to be answered by the rights of Indian fishermen who are illegally detained and brutally assaulted by the Lankan Navy. Is a case point as how would be the law treat the action by foreign governments, naval force, whether as an act of crime or an act of their national maritime security policy and under the new law. Its application extends beyond 200 nautical miles, and how would the legality concerning the new law endorsed. With these words, sir, I once again support this bill. Thank you, sir.
इस विधेयक को हम फिर डिबेट और आगे भी करेंगे और उस समय मंत्री जी का जवाब मिलेगा. सभा की कार्रवाई कल गुरुवार दिनांक 8 दिसंबर 2022 को 11 बजे तक के लिए स्थगित की जाती है.